have what I did the last time was I made up a outline, and so I'm just kind of going from that outline. Um, some of this stuff may be redundant from our first one, but I want to go over a few things I think is important for me to go over with you. Some of the important things we covered the last time. We titled it Paternity and Child Support, the Good, the Bad, and the Ugly, Part 1. So this is Part 2. But as an overview of what we discussed in Part 1, one of the biggest things was the describing the difference between the rights of married and unmarried fathers, because there's a big difference. The biggest difference is that when a child born during a marriage, paternity is automatically presumed to be with the husband, which means that for people who are still married but separate and wife is still having children, husband probably doesn't realize he's a legal father and he has to take actions to disestablish his paternity. And there are certain steps that you have to do in order to do that. The first of which is be very diligent. You need to raise the alarm, raise the red flag as soon as you find out. The sooner you do it, closest in time to birth of that child, the better off you're going to be. The so it's a presumption, but it can be overcome. There are certain steps. Vernicia, I do not believe I made the distinction, and yes, I think I did, on the issue of a child born to a woman who's married with the unmarried biological father. I went over that, didn't I? The distinction. I don't remember if I did. But I'll go over it. Simmons v. Perkins, yeah, because that's the case. Simmons v. Perkins is that the other thing, Jamile, is that if you as and actually, now that I think about it, the biological father could be married to somebody else. His marital status doesn't matter. But if a man has a child with a woman who is married, the previous law was that he didn't even have any standing to do anything. Because that husband was the legal father, he couldn't even file a court case. Court cases were thrown out for a lack of standing because he had no rights whatsoever.
Attorney Jackson, just to clarify, when you say standing, what does standing mean for?
Yes, so standing means that your ability to bring a lawsuit, for you to file a lawsuit. So you can file it with the clerk of courts, but the court then determines, do you have the right to file it and pursue it? And if you do not, if you don't have proper standing, then the court dismisses it, saying you are not the proper person. And that's what the biological father previously was, a biological father's situation. There was a case law, though, that came out 2018, Simmons v. Perkins, and that kind of changed things around. And actually, in some of the various circuits in the state of Florida, some of those circuits did allow the biological father. They had, some other steps that they would do. But I believe the fifth was one of the ones that it was very harsh.
And when we're talking about circuits, sorry, just because I want to make sure that people are able to understand. So when we talk about circuits, what does that mean?
So there are, I forget how many, there are 67 counties in Florida, but there are various circuit courts. And each circuit court has, most of them have multiple counties within that court. Good example, Ninth Circuit Court is Orange County and Osceola County. And so Seminole County is, 18th Circuit is Seminole and Brevard. So each circuit can have multiple counties, and the rulings that come out of those, for each circuit, we have the District Court of Appeals. And how many, is it 5? First?
Don't give me the line.
I forget how many there are, but we're in the 5th. Orange County is in the 5th DCA. We abbreviated DCA. And that includes, I don't know all of them, but I know Orange, Seminole, Lake, Brevard, Osceola. They're going to be, because the 9th Circuit it goes to the 5th DCA. So when I say the circuit, so the DCAs, the 5th DCA could have a ruling. Their ruling was biological fathers didn't have any rights, but there could be other district court of appeals throughout Florida that said, yes, you can. So I have a case like that now as far as imputation of income for incarcerated persons. There is a split in the circuit. Splits in the circuit, meaning one circuit says one thing. I'm sorry, I'm saying circuits. I should be saying DCA. One district court of appeal says something, another one says something else. The Supreme Court has to resolve that conflict. So I have a case where opposing counsel is saying, hey, my guy was incarcerated. He shouldn't have income imputed to him. The 5th DCA has found, yes, he should, because the acts leading to his incarceration were voluntary. That's their stance. So we're imputing income to you because the only reason you can't earn income is because of a voluntary act. There are other district courts of appeal, though, I think it's the 4th and the 1st, that reach different conclusions. And the case law that I'm using in that situation certifies it as a conflict to the Supreme Court. But as of yet, the Supreme Court has not resolved that conflict. So depending on what county your case is in is what case law you have to follow.
I just want to plug in right now. Jamal, this is one of the prime reasons that people should seek counsel, because there are several intricate factors that can affect your case, and somebody can lose on a technicality when they actually have a good case. So it helps, because I do know that there are some savvy people who are able to represent themselves, and family law is one of the areas that there are pro se people who represent themselves in court, but it is always good to have counsel.
Yes. Gotcha. Because there are, like she said, there are a lot of nuances, especially in this establishment and disestablishment. And so that's on the issue of married fathers. Unmarried fathers are the complete opposite. They have no rights whatsoever until they go to court, right? So paternity itself is established either by voluntary acknowledgement, which can be a form that you file with the vital statistics. The acknowledgement of paternity form is what is signed by both parents at the time of the child's birth, which allows an unmarried father's name to go on the birth certificate. So another one of those nuances that Vernisha mentioned. When you say it's the name on the birth certificate, and the courts will say, just because your name is on the birth certificate, that doesn't give you the right. What gives you the right is the acknowledgement of paternity. Part of the issue, and actually some judges, in my opinion, are not on point with this, because the statute that establishes voluntary paternity specifically says that a voluntary acknowledgement of paternity, that actual form, vital statistics form, if it's not rescinded within 60 days, you have 60 days to rescind it. Either party can challenge it. After that, it is a legal establishment of paternity. So you don't have to go to court, although some judges will argue, yes, you need a court order to establish it, but there's more than one way. That voluntary acknowledgement, you have to request it from, you can get a copy of it, but you have to request it from vital statistics. You can't go to the health department like you go to the health department and get the birth certificate. You can't get that acknowledgement of paternity. I discovered it accidentally and have been requesting them ever since. You send a money order for $14, a copy of the parent's ID with a request to vital statistics, and they send it right off to you. Okay. And then what I do in that case is my paternity cases, I file that to say paternity has already been established. Now I'm asking for a parental responsibility. So some of the things with the paternity, Once the paternity is established through voluntary acknowledgement or through the courts, you can file a court action, and that's what the actions for an unmarried father is called, a paternity action. The court
Attorney Jackson,
yes,
really quickly before you move on, I have a question for Jamal. When you speak with fathers who are facing these paternity issues, do you find that they are having, they're finding out about their children after the birth, or more so after birth or at birth?
More so I would say more so at birth.
Okay.
Is when all of this is happening. There's I think we have 2 that are after the birth, and I believe this number is going to continue to grow for us to have more statistics on either side. But I have seen at the birth and after the birth.
So for those who are finding out about the children at birth, if they have a question of paternity, do you see that they actually do DNA tests?
Yes, there's been a couple that have done DNA tests. There's been a couple. I've had one father that is actually in this situation that wants to know, should he do the DNA test? So it's
good
really
question.
Which leads me to Attorney Jackson.
it is very strategic. And oh, Vernisha, I forgot to tell him my favorite.
Well, that's what I was asking. That's exactly what I was asking.
Yes. My stance is that, I'm sorry, pronounce it again.
Jamal, you got it right.
Okay.
You're on point.
All children, underline, bold, italicized, all caps.
All right.
All children, this is my belief, should be tested at birth. Yep. Okay. I said it. And I mean it. Married and unmarried. Because there are a lot of men taking care of children that are not theirs. So as I tell people, I'm a step parent. So I've raised children that I didn't birth. You know, people get do adoptions, godparents, grandparents. You can raise and love children you didn't birth, but you're doing it voluntarily. That's how it should be. You should make the conscious choice and the educated decision to do that. You should not, however, be raising a kid that you think is yours only to find out it is not. Vernisha has the case, the unique intersection of a married father, and this is why I asked for it. My whole family knows. They laugh about my grandkids. All of them been swabbed. Trust me. Every one of them.
I hear that.
But Vernisha has a case right now through the Virgil Hawkins program where a husband, he only questioned one, right? Initially, Vernisha?
Right.
He questioned one, did the paternity test. There's 3 children?
5.
Oh, Jesus. 5. None of them are his. None of them are his.
Wow.
And I just want to say, like, it's commendable for a father to take care of a child, you know, under the understanding that the child is his. Right. However, I don't think men understand what happens when you find out that the child is not yours and you try to do some things because you are still financially obligated to take care of that child, and it's very difficult to reverse that. So it's best to be in the know from the beginning, because as Attorney Jackson will discuss later on about the establishment and disestablishment of paternity, there are deadlines and there are factors that they must prove in order to achieve the desired outcome, whatever it may be.
And think of it like a statute of limitations. One of those is the case has to be filed within 90 days of getting the paternity test results.
Right.
So, you know, that's a big one.
And just to say, so when we discuss statute of limitations, that means what, Attorney Jackson?
That means that after you have a certain number of days, in that particular case, it's 90 days. And it's similar to like in criminal cases where you normally have that, well, civil too, but it's a number of days, a certain amount of time, which after that time, you're cut off from filing the case, from getting any relief. An example, years ago, and you probably still hear a lot of them, but I remember there was this real prominent one. It was in Florida, and it was all over the news. A father was required to continue paying support, even though a husband, former husband, even though he found out the child was not his. And I said to my sister, we were talking about it, and I said, I bet you there had been a divorce. And I said, I bet you he said he'd take care of the kid, or he didn't raise it in the divorce. Now,
Right.
that's a critical element with that timing too, because if it came up, if he questioned the paternity of that child during the divorce, and he said, no, never mind, I know the child is not mine, like Vernisha is saying, being a stand-up guy, being commendable, he's going to be in trouble. And that's exactly what happened. When I pulled the case, they had a divorce like a year or two prior to when this ruling came out. During the divorce, he said, not sure the kid is mine. I think he or she may not be my child, but you know what? I'm gonna, no, we're gonna move forward in the divorce with that child. He and mom were getting along. Year or two later, he gets upset, angry, whatever about something, says, you know what? And that also means he was paying support for that kid.
Right.
Year or two later, he changes his mind. Too late. Judge has said you knew about it at that time, you acknowledge, because at that point, it's a voluntary acknowledgement of paternity, because you don't have to be the legal father, the biological father, to be the legal father. So he had acknowledged paternity of that child, accepted his legal responsibility, and they don't just let you turn it on and off, which makes sense. You know, people shouldn't be able to just run in and out of a kid's life. Okay, today I'm your dad, but tomorrow when I'm mad with your mom, I'm not your dad.
Right. Right.
So that's the public policy, principle behind it, that they don't want paternity to be able to be established and disestablished, easily. They also, another one.
Excuse me,
Uh-huh.
Ms. Mamata. Can you just explain what the disestablishing of paternity is, what that means?
Yes. And so the disestablishment means when you are not when you find out you are not the biological father, but you have you have been deemed to be the legal father. That could be husbands, because they are automatically the legal father. And it can be unmarried fathers who initially voluntarily acknowledged paternity, because you have that legal obligation even without a paternity test. So there is a court process to disestablish. You have to file a case just like you want to establish paternity through the courts. You have to disestablish paternity through the courts. And
Okay,
if the
and that's
mom
what
agrees with you,
correct?
I'm sorry,
Is that within the certain time frame of statute of limitations that you
that's the
mentioned?
90 days within getting so it's a whole process, but that's just as far as when you file the case. Now, I
Gotcha.
should state that if mom agrees with you, if mom is on board with you, it's relatively easy. You get some
Right.
affidavits done, you file the case, do the affidavits, and get an order. If
Right.
mom is not on board with you, that's when, it's a longer court process. Now, one of the first steps is getting the right to have a DNA test. It's part of that disestablishment, because that's not automatic either. If an unmarried father has signed that acknowledgement of paternity, then it's not, you have to come to the court and say why you're now challenging it. If it's outside that 60 days, remember the 60 days for the voluntary acknowledgement, if you didn't challenge it, you signed it, now the kid's 2 or 3 years old, you've got to file that case to disestablish. And one of those is newly discovered evidence that, hey, at the time I signed that, yeah, I thought I was a father, but there have been some things that have happened since then, and you have to be specific, not just a general. And by all means, you can't say, you know what, I always had doubt about that kid. But no, this is new to me. I just discovered it yesterday. I was in the store, dude came up and told me, what you doing with my son? You've got to give a reason why the court should overlook the fact that you've acknowledged paternity of the child.
Conversations with the mother. He's
Yep.
not your child. She's not your child.
Uh-huh. Mm-hmm. And then you have to be current on your child support, or give a good reason why you're not current on your child support, because you would have had a legal obligation to support the child. And so, and again, the public policy behind that is, we don't just want dads giving up paternity. Oh, you want me to sign off? I'll sign off to avoid their legal obligation for the child.
Right.
So that's the reason they don't make it real easy, because
Right.
you know, people who don't have a relationship with the child be like, okay, well, let me just sign over my rights. That can be done as well, but through like step parent adoption and that type thing. You generally have to have someone to step into the shoes of that father. You know, the court's not just going to let you know, a father sign off and the kid doesn't have a father. Another point I wanted to bring up is the issue of legitimacy and paternity kind of overlap as well. On that issue of the married parents, a child born before the parents were married, if the parents subsequently marry, that child is considered a child of the marriage. That's another thing that Florida law allows, because they, you know, want children to be legitimate rather than illegitimate, which affects different things, even to inheritance. You know, whether you are a child born of a marriage with the same parents, you can inherit differently based on your status. Um, so that's the issue with the married versus unmarried, the voluntary acknowledgement of paternity, um, establishing paternity. Now, when you file a paternity action, when a father files a paternity action, there's actually several things that are done with that. One of them is establishing the paternity, but another one is parental responsibility. That's decision making, being involved in decision making. And that's huge until they go through the court process. So, as I said, once they establish their paternity, okay, you're the legal father, then you need to come in and establish your rights. That's when you go to the court.
A
The court,
question.
uh-huh.
So is this what applies to when fathers want to spend time with their children, and a mother will hold something over their father's head,
Mm-hmm.
or use the child as a pawn, saying you can't see the child unless you do XYZ? Is
Mm-hmm.
this the way that a father can bypass all of that unnecessary demands
Yes.
and obtain time sharing?
That's exactly right. That's exactly right. This is where the father goes to establish his rights, because establishing paternity is not one and the same with establishing rights. So that's what's critical. One of the biggest things that comes out of it, I'm kind of skipping ahead, but the reason a father wants to do it is relocation. Once that case is filed, and now that applies to married and unmarried. Once a case is filed, neither parent can move more than 50 miles from where they're living at the time that case is filed, and they're served. So it needs to be filed and served. And that's huge, because you have, like Vernisha said, one party choosing to leave the state, or, you know, do something to keep the child or children away from the other parent. So for married couples, they have the same rights. So until a case is filed, either parent can take off and move and go to wherever they want to go. But if you get them served before they move, they can't relocate until it goes through the court process.
Gotcha.
The and as I said, it has to be have to be served. So you want to establish parental responsibility. The standard in Florida is shared. You have to give additional facts or a basis if you want what's called shared with decision-making authority, meaning, so let me go back to shared. Shared parental decision-making means that the parties have to confer and make an attempt to make a mutual decision regarding major decisions for the child or children. That's education, medical, um, a lot of different things. Florida law also allows, though, for mental health treatment. Either parent can go get mental health treatment for the child, but school and medical are big issues. I deal with this a lot with fathers. Not knowing where the children go to school, parent not tell them, or not being able to go to the school, not being able to get information. So that parental responsibility also is access to information. Both parents have the same access to information regarding the children, but routinely, and especially with the schools, their stance is the enrolling parent has all the control.
Right.
Florida statutes say something different, and Florida case law says something different. So that's one of the first things. Now, what I do is I generally deal with the school board attorney. I go through the legal department because dad shows up and he's going to get nothing but flack from the school. Mom probably doesn't have him on the paperwork. They don't know who you are. You know, what's supposed to happen is all you need to do is that's when the birth certificate is important. The school should have it. I do a whole process for my dads. I contact the school board attorney's office first, but before I was even doing that, I would have them get a copy of the birth certificate because they can from the health department if their name is on it. Get that birth certificate, have that shows your name, show up at the school with a copy of that birth certificate, even though they should have it. So even if your name is not on the school records, hey, I'm the dad of this kid. I have a right, to information, and a right to access the child's educational records, and access to the child at the school are two separate things because schools get kind of, hesitant about that.
Right.
But they go there, show their ID. That's the only reason. If they don't have ID, if the school can't verify who they are, that should be the only reason they're turned away. Although that's not always the reason or the result. And so that's why I started going through the school board attorney's office. So what I would do is get the child's information and say, hey, here's the child, here's dad, here's his ID. Can you tell me? A lot of times they don't even know what school, but at the school board level, they can tell you. Hey, this child's enrolled at this school. They usually copy the principal or an attendance clerk or whatever. Please provide X, Y, Z. And most recently, they just send the records directly to me, rather than dad going there and getting them. And then, we go through and they have a process. If dad's name's not on it and he's supposed to be, they let dad add his folks, your emergency pickup, that type thing. So
Right.
that's why it's important to file that case. That's how you get your rights. Parental responsibility, the shared, the next level that you can ask the court for is shared with decision-making authority. Still have an obligation to confer with the other parent first, but if you guys can't make a mutual decision, then the court appoints one parent or the other to make that final, and that's often called ultimate decision-making. So with the ultimate decision-making, then you, one parent or the other can make the decision, basically the tiebreaker.
Gotcha.
Sole parental responsibility. Now, of course I get that a lot,
Right.
from moms and dads. Because like I said, I represent mothers too, come in, I want sole custody. Not happening. My response usually is not happening in the state of Florida. It is very difficult for public policy reasons. Can't just shut a dad out because you don't like him. The relationship ended and now you want to go find him another daddy. You can find him a stepdaddy, but dad is still going to have the rights, and your new husband, your new boyfriend is not going to be able to dictate to dad how often he sees his kids, what decisions he can make, and what stepdad's decision rules because he lives under my roof that would be a no. I
Right.
feed him. Yeah, you can feed him all day long. Thank you.
Thank
But
you.
when it comes to the decision making, dad has, a say in it. Another thing that is important for fathers to file, another reason for them to file, Florida statutes actually state that, and I have the one for that one, 744.301 subsection 1. It's the last sentence of the paragraph on natural guardians. And the statute reads, the mother of that sentence reads, the mother of a child born out of wedlock is a natural guardian of the child and it is entitled to primary residential care and custody of the child unless the court enters an order stating otherwise. What that means is, until that father establishes his rights through the courts, mom can do whatever she wants to do and does not have to involve dad. Doesn't have to give him any visitation or anything. You got to go to court to get it. And that's what the part taught, unless the court enters an order stating otherwise. That's that order you need.
Okay.
So just to note, this is beyond simply signing the acknowledgement of paternity and signing the birth certificate. This is an additional step, actually going to the court, petitioning the court for paternity, correct?
Yep. You must petition the court. You must petition the court for your rights. That's the key. You can have the title, legal title, and the obligation that you are the legal father, but to establish those rights, to invoke those rights, you have to go through the courts. You don't need courts to establish your paternity, but you do need courts to establish your rights, your parental rights. So that's the big distinction. Another thing that's common, Jamil, and you probably have fathers who've done this, and moms and dads do this, calling the police. The police do not have the authority to enforce a court order other than a pickup order, an order that has language, what we call the law enforcement clause, which gives law enforcement the authority to actually take possession of the child from one parent and give the child to the other parent. That's a pickup order. Okay. If you have in the court order that we get that says, yes, Bob is the father of this child, he has parental rights, he has time sharing, he gets the kid every other Wednesday and every other Thursday, Friday, Saturday, whatever that visitation, we used to call it visitation under the statutes now, it's called time sharing. They kind of shied away from custody and visitation. Time sharing is the term that's used. So sometimes that can be confusing for fathers when they, what the heck is time sharing? That's the new language that they use. But if he has a court order for time sharing and he goes to pick up the kids and mom says no, calling the police has its purpose, because I do have parents do that, mom or dad, but for a different reason. I do it for record keeping purposes, because when you call, there's a dispatch record. And so it's saying, and they're going to note what you called and said. What is your reason for doing it? A lot of jurisdictions will do what's called civil assist or civil standby for exchanges of children. They will do that as well, but they can't enforce it. They will tell you, hey, we can't force them to turn the child over. We can stand by. You can ask them and we'll be here, because of course, if law enforcement is there, less likely for something, bad to happen.
Correct.
But here's another issue with that involving law enforcement. It depends on what officer you get, okay? Because you have some that are not knowledgeable and don't know, and they will tell one party or the other, you have to turn over this child. And they have even threatened, I've had cases they threatened to arrest them. So the way you back them all the way down is you say, under what authority are you asking me to turn over this child? Do you have a pickup order? I don't even do that longer one. I tell my clients, ask them, first question is, do you have a pickup order? And is it certified? Courts don't really like it if you look at, they play with that little distinction, but technically, if they got a pickup order, it's not the certified copy, still don't have to turn over the kid, but a pickup order is the only reason. I have had numerous times police show up, they call me, I'm on speakerphone. Sometimes the officers, they know what time it is because they're like, I'm not talking to you, lawyer. Yeah, I bet you're not. Because I'm on the phone yelling, excuse me, officer, do you have a pickup order? I'm not aware of one. Because, you know, this is a civil matter. The major buzz phrases for police being called to time sharing issues is, do you have a pickup order? And this is a civil matter, which means you don't have the authority to do anything here other than document you were called, right? They've asked me to turn over the child. My answer is no. She asked me, you asked me, my answer is no. But you will have some officers who are very heavy-handed, like I said, who will say, well, I'm gonna arrest you. You don't turn over this child, I'm gonna arrest you. Trust and believe, when it comes down to when it goes to higher ups, because I will go to higher ups, and they have to explain it, they'll say, no. We didn't tell them they had to turn over the child. You know, they voluntarily did it. That's going to be their story that they didn't force. But like I said, I've had on more than one occasion, too many to that I, more than I'd like to admit, where law enforcement does the whole thing of, pick a side and say, okay, no, she said, you need to turn the child over. You need to turn the child over. They need to remember, no, you don't. And if you're having a problem with that officer, call for a supervisor. Call for a supervisor.
What advice would you give to someone who does not have an attorney and they are hesitant to involve law enforcement for various reasons?
Right.
What advice would you give them in that same situation? Is there anything that they can do without including the law enforcement?
Yeah, they can choose to turn the child over. They can choose to turn the child over, but document it, text it, email it. And so that there's a written record. Hey, we had agreed that I was going to keep Sam until 7 o'clock, but you showed up at 3 o'clock, threatening to call the police. I'm going to turn him over, but, I believe I'm entitled to make up time sharing, make a written record. That's the important thing. That's one of the reasons with the police being called sometimes, is to have that record to show. Or I had a client who mom would show up late or not at all. So you have law enforcement come to do the civil assist, the civil standby. They come there and say, okay, yes, we were here at some of the exchanges are Orange County Sheriff's Office by the flagpole. We were here at the Orange County Sheriff's Office by the flagpole at 6 p.m. Other parents not here. I've been waiting here 15 minutes. And see, in that dispatch record, that's what they can say too. It's 6:15. We were supposed to meet at 6 p.m. The other parent is not here. I'd like to have, deputy come and just be able to attest that, the other parent is not here. Kind of look around the parking lot and that type thing.
For those who do not want to include or involve law enforcement, I just want to reiterate, make sure that the communication is written. Not just verbal, not a phone call. Even though if you have a phone call, you can follow up with a text message and or email per our conversation and explain what happened and it just to make sure that you're memorializing it so you can save it and you're creating a record, a written record.
Yes. And voicemails from the other parent. That can be used as well. Because you have situations where, and like you said in the written record, hey, I called you 5 times. You're not answering. I'm going to stay here another 5 minutes and then I'm going to leave. It's a record of memorializing it at the time it happened, right? That I reached out, I tried to, contact you. And another tactic that I use or strategy that I use, Jamile, is I actually tell my, female and male clients this, moms and dads. One of the best things to do at the beginning of a case, or even before you file, when you're trying to take your control, because my stance is that the underlying issue of all of these issues is about control. One parent or the other is trying to control that situation and usually has controlled that situation. And so I tell my clients radio silence, go silent. They should not be able to call your phone and have you just pick up the phone whenever they call. You can do that by, you force them into writing. You force them into text messaging or emails. Shoot them a quick text. Hey, can't talk right now. Text me what you know. Can just send me a text and I'll respond as soon as I can. That's forcing them into written communication, which can be used in the courts. You want writing because it's a whole bunch of he said, she said. The courts like written communication, and the court has several tools that they use in family law. One of them is free. Well, there's a free version, but of course, as anything, the paid version is better. Called
Right.
Talking Parents. It's a communication tool that it sends, it tracks when you read them, when the message is sent, when the message is read, and then of course it would show what time you respond or if there's no response at all.
Right.
Um, it is very, courts really like it.
Yeah,
Because it can't
I've
be
had a
altered.
father or two on the Talking Parents app actually.
The other one is Our Family Wizard. It's a paid one. It's like $99 a year. I think it has more features. The court can sign up and have their own account. But either way, there are these communication tools. There's another one that I need to look into. I've heard about it. Vernisha, if you can remind me, it was created by a father. It was created by a father and it's similar to Talking Parents and Our Family Wizard.
Okay.
But it has a lot of different things. But those tools have calendars. They have where you can upload documents. So, for instance, if you have the report card or a certificate or something that the kid had, the parents can share that. On the access to records, going back to that, another thing, Jamal, that I and it's for mothers and fathers. Parents are used to, when people are in a relationship, they're used to dealing with each other in a certain way, right? So that's one of the reasons I say go radio silent, because look, we're going to start over from scratch and we're going to start your communication, your co-parenting a different way, or start your co-parenting because a lot of times there hasn't been any. And part of that is accessing information. Social security cards, birth certificates. So of course, what I get a lot of times from dads is, mom won't give me the kid's birth certificate. You don't need it. You don't need to get it from her. Get it yourself. Mom won't give me the birth certificate. I've asked her. Don't ask her. Go get it yourself. Um, the mom side, he got a copy of my son's birth certificate and social security card without my permission. He doesn't need your permission. He's entitled to it under Florida law. And
Right.
Jamal, I know you see it all the time. The biggest issue is dads don't know their rights.
Right.
Like without a court order or anything, you can get that. The birth certificate, you start with the birth certificate. If your name is on it, dad comes to me and says, I don't know if my name's on the birth certificate. Send him over to the health department. We can figure that out real quick. Because
Right.
if you go to request that birth certificate and your name's not on it, you can't get it. So
Right.
that helps us know how we start. I start with the birth certificate, then get with the birth certificate. Sometimes you need some other information though to get the social security card, but you can order that as well once you show that you are the parent. And one of the things they ask is they want recent school or medical records. And I was told that's because that keeps down on fraud of people trying to get social security cards for deceased children that are deceased. So they make you produce recent school or medical records. So you can say, yes, this is a child that is still living. But similar to the schools, sometimes you get that representative from the Social Security office. And I've had this happen more times than I'd like to admit, that says, you need the mom's permission. No, I don't. No, he does
Right.
not.
Right. Right.
um, you know, so sometimes they are just used to operating a certain way, the same way, you know, families operate when mom may have been the primary person handling documents and getting information. So things like birth certificates, social security cards, Information from the school, the child's school records. Some of the schools will say you need mom's permission. No, you don't. All you need to show is that you're the parent and you have access. Now, there is a federal, are you familiar with FERPA, Jamil?
Say that name again. FERPA.
FERPA, FERPA is the
No.
acronym.
No.
It is federal legislation. What, we found that before, Vernisha. Let me tell you what.
While you're looking that up, I just want to say that, you know, when fathers are attempting to obtain this information, it might be good for them to carry along with them the rules that govern how to obtain that information, just in case you encounter somebody who does not know what they're talking about. So that they can say, you know, pursuant to this.
Yes. And that's what I usually give them. I give them the statute, the Florida statute, because a lot of it is about educating these entities, daycare, schools, doctor's offices. FERPA stands for, hold on, Family Educational Rights and Privacy Act. And it was enacted in 1974, and it protects the privacy of student education records. What it also does is, part of that is that outlines a parent's rights to their child's educational records. Florida has adopted, like a lot of federal laws, Florida has adopted a version of FERPA. So there is a state and federal obligation and right to have the information. A parent has that right to their child's educational records.
Absolutely.
So that's another one when they tell you, no, we can't do it. And FERPA has some penalties for violating it. So a lot of times, you know, if you go in and a parent goes in to get it and they're asking for it and they're being denied, hey, my understanding on the FERPA, I'm entitled to this. In the schools, they know what FERPA means. You get a big change in attitude when you mention FERPA.
Okay. We'll keep that noted. Duly noted.
Yes. Yes. And so, you know, that's the thing as far as accessing information, finding out. I tell parents, especially dads, get the information, go to the school directly, first of all, so they see your face, so they know who you are. You can create your own, you know, a lot of counties have, school districts have the parent portals so that you have your own account. You can, there's a wealth of information in that. You can communicate with the teachers directly. Find out your child's schedule, who their teachers are, the contact information for the teachers. Communicate with the teachers directly, not through the other parent. You do not have to communicate through the other parent. Do it directly yourself. And if you get pushback or you see the school saying, you know, well, mom said, mom does not control my rights. You know, I have independent rights. There, the part of the statute that talks about access to the records that each parent has an independent right to this information. They don't need the other parent's permission or approval. Or notification. A lot of times say, well, you know, we'll get these records to you, but, you know, we got to notify mom first. The only reason that a school can deny a parent access to records, or that child actually, is if there's a court order restricting it. And that's one of the things that the Florida statute says too. If there's an order, for instance, if there's sole parental responsibility, then no, you don't, you know, there's certain things that you don't get to make the decisions about. But if there's a court order, a lot of times what the schools will do too is they'll allow a mom to restrict a dad's access without showing a court order. So when I come into the picture, the first thing I say is she has dad listed as not authorized to pick up the children, not authorized to get information. Where's a copy of the court order restricting his access? Did she provide you that? And so a lot of times they'll say, well, they didn't, but they'll give them 2 or 3 days. That's one of my beefs with the school districts now, because no, at the time she did that restriction is when you should have been asking her. If you don't have it now, when my dad comes in asking for this information, no, we're not waiting 2 or 3 days. We end up having to wait 2 or 3 days anyway, but I give them the pushback. Like, no, we want it right now. Because, and it's to, teach them, to educate them as well. You shouldn't have allowed this. This, restriction is unlawful. It violates Florida law. So, but that's the thing on parental responsibility, access to information. On the relocation we talked about, no more than 50 miles, and it is as the crow flies is what the standard is, meaning a straight line, not how you drive to get there, because a straight line distance to there, um, it may take you, 70 miles to get there, but you know, right at 50 miles, because there are some places that, I live in Lake County, so trust and believe. It's a roundabout way to get to some places.
Mm-hmm.
My sister and I both live in Lake County. It's 45, no, it's 55 minutes between our houses, and we both live in Lake County.
Wow.
So even within the same county with a certain number of miles, it can be close. So it goes by the miles, not the time, and not your driving route, a straight line. And Google Maps has that feature. You have to, it can be a pain in the kazoo sometimes getting it, to do it. But Google Maps does have that feature. So I tell parents when they're thinking about moving, first thing you need to do when you're looking at that new address is see how many miles between the residences.
And this applies after a petition has been filed and the opposing party has been served.
Has been
correct?
served. Yes.
Yeah.
Now, along that same lines, so what happens with the relocation if you don't do it the right way, and there's a certain process and procedure for that as well, if you don't request relocation, so that relocation requirement means you can't move more than 50 miles from the current residence without the other parent's written permission. I mean, you can't just say, yep, I called them up and they said yes. You can't prove they said yes. Or a court order. So the other parent can agree for you to move, but it has to be in writing.
Right.
And if not, then you have to file with the court and follow that proper.
And that works for either parent, correct?
Either parent. It applies to both. And what happens is, so it applies to the person who's filing the case and the date they file it. It only applies to the person, the respondent, when they're served.
Okay.
So for people who are wanting to move, and I had this recently, someone consulted me about moving. Oh, well, I want to tell dad. No. You don't want to tell them ahead of time. It was an unmarried mother. You can go wherever you want to go, Now, the flip side of that is, and part of that, Jamal, that process of relocation, it calls for, that's when you can get a pickup order. It calls for, they're going to bring, Florida has jurisdiction over the child. So what happens is if you relocate outside of the requirements, the court will order that child to come back. And it's a big deal. Trust me. It can be, it is life altering, the effects of the relocation. Had examples, I've been on both sides of it. I have, and like we talked about the service, I have served people the day before they were scheduled to move. And I've had clients who were served the day before or the day of. As long as they get served before they leave, they cannot go. And then think about the implications of that. You've 9 times out of 10 left your job because you're preparing to move, packed up your house, found a new job, only to be served and find out you can't go. Now, I should say that the child can't go.
Right, the child can't go.
The
Now,
child,
if they were to go before that order is given to that parent, then it's all about time, right? If you don't get it to the other parent in time, then they can go.
They can go, but the other part of that I was going to talk about that goes hand in hand with that is what state has jurisdiction over the child. And so Even
And what does
if
jurisdiction mean, attorney?
jurisdiction means the court has authority, that they have authority to make a decision about that subject matter. There's subject matter jurisdiction and there's personal jurisdiction. Personal jurisdiction is, does the court have authority to tell that person what to do? And do all of the parties have, does Florida courts have jurisdiction? So of course they would have, you've lived in a certain, in Florida for 6 months, at least 6 months, Florida courts have jurisdiction. For younger children, less than 6 months, then it's, based on that as well, where they've lived the longest. And then also the subject matter jurisdiction. So yes, a family law case, the family courts in Orange County, Florida is going to have jurisdiction over a family that had been living in Orange County for at least 6 months.
Gotcha.
So the issue with the jurisdiction is every decision that's made relating to children in family law, because dependency law is a little different. Dependency law is when the state gets involved and takes custody of children. But in family law realm, the standard is the best interest of the child. Every decision that the court makes has to be in the best interest of the child. And there are factors in Florida statute, 61.13 subsection 3 is the best, what's called the best interest factors. And what the statute says is when the court is establishing or modifying time sharing, they have to consider and evaluate this list of factors. I think it's A through T, and T is like the catch-all, any other factor. But with relocation and moving children, the best interest factors can also be used to bring a child back. Number one, Florida's going to have jurisdiction over that child until 6 months and a day. After that 6 months and a day, Florida doesn't have jurisdiction. But if a parent has, and a good example is, and I had one early in my career when I started dealing with the relocation, dad dealt with the children, had his sons, 2 boys, 3 or 4 days a week. He had them in karate and boxing and some other stuff. He would pick them up from school. I think Wednesday was his dinner visit with them. He didn't even keep them a lot overnight, which overnight is critical when you're doing the time sharing. But he had that contact, I think he talked to him every single day, and then he picked them up from school 3 or 4 days a week. Mom picked up and took the children, and the red flag for him was every Wednesday or whatever it was, he picked them up. She contacted him on Tuesday and said, by the way, you don't need to pick the kids up tomorrow. Pick the boys up tomorrow. I'm going to take them somewhere. And he said she never took them or did anything with them. And it was like their boxing night. Well, it was an extracurricular activity. And he's like, well, why should they miss? He wanted to contact. So he immediately calls the school, finds out mom had withdrawn them. Mom had withdrawn them from school. And only thing she had was to move to Virginia. And, he called me hysterical, but you have to be strategic with a lot of this too, Jamal. You can't just jump the gun and say to mom. So again, I had to do the whole silent thing, because if you don't know where they are, remember I said you got to serve them. All this stuff, notice is everything under the law. You have to know where the person is in order to serve them. Mom had gone silent. I said, you got to be quiet. Don't send a text saying I'm getting a lawyer and I'm coming after you. No, go silent. Just wait it out. She's going to be waiting to see your reaction, to see if you say anything. And whatever the new school that she's taking them to, they have to send to get the records from the old school. But if you jump the gun and give her heads off, she might not put them in school. Yeah, she's supposed to put them in school. But if she knows you're looking for her, they're not going to be enrolled in school, So sure enough, that's what happened. The school absolutely adored Dad because, they knew how actively involved he was. The minute they got the facts, we found out, we got everything done, we're able to get the information, get the motion for the pickup order, and we were able to get a pickup order.
Awesome.
And it was in another state. Now, the technicality with when you get a Florida order, remember I talk about jurisdiction, a Virginia court doesn't have the jurisdiction to enforce a Florida order unless you go register it. So there's a process for that as well, which can take some time. But what we did is we coordinated with the school. That's why I say if there's cooperation on the other side, and what I ended up doing was I coordinated with the school and the school resource officer. It was nothing but God in this particular case. One was in elementary, one was in middle, and it was one of those combined campuses where the elementary and the middle were right next to each other. They shared a sidewalk. So dad wasn't having to try and go in two different places and have one alert the mom and all of that. Two different principals. It was night and day of how the principals were dealing with me. But I had that one resource officer who worked on both campuses. And let me tell you, he worked his magic. Got there, got the kids, and they gave him the opportunity to get back on the road. And I think they waited and gave him an hour head start before they contacted mom and said, can you come to the school? She gets to the school and they're like, dad came and picked up the kids. He has a pickup order, you know, that type thing. So being strategic, you know, not going Facebook Live with your business. You know, we all know that
social media.
Yes, social media, period, is people overshare, you know, people overshare. And I never played cards. My mom was didn't allow us to play cards, so I didn't grow up. So look, I don't know how to play poker, but I can strategize out of this world. Trust me, you know. And so you have to do what's best. You have to take the emotional side of it, and of course that's hard, you know. And I tell my clients, listen, I don't have that emotional stake in it, and I tell them I apologize if I'm not seeming as empathetic, because when they're talking to me, I'm thinking about the legal issues,
right?
So, because a lot of what is emotional is not legal, has nothing to do with the process. You know, it doesn't matter that he slept with your sister. It matters to you, but in the grand scheme of this case, this family law case, it doesn't matter.
Speaking of Attorney Jackson, can one parent dictate who the children are when they're with the other parent?
No, unless there is a threat to the child. So again, if you're, and trust me, you know, family law has these bizarre situations. So yeah, there can be a situation where your ex-husband, or matter of fact, your husband moved over to your sister's house and now he's with your sister and now you don't want the kids to go over there. No, unless there's a threat, if you know, a threat of harm to the child. Now, of course, if you have a sex offender, that's going to be something different. But no, there's no way to dictate that. And going back to the issue of the relocation or moving out of state in the best interest of the child, if there is a threat of harm, I had a case like that too, where the mom moved out of state to move into the household with a registered sex offender.
Wow.
In that case, it not only did I get a pickup order, but I was able to, the state attorney's office in that other state was able to assist. That's when DCF gets involved. And they executed, we had two different addresses. They executed on both addresses. And the person, mom didn't answer. They went into one of those gained entry to the home, and got that child. Dad had to fly up, get the child. So, you know, there are a lot of things that can be done. Jamal, one of the things, and I'm sure you already talked to dads, and that is, I just mentioned the whole emotional side of it.
Yeah.
You really do have to stay calm, because your delivery, your attitude, And dad may have every right under the sun to be upset, you know, but don't let them use that as an excuse to stop you from getting what you need to get,
Mhm.
you know.
Right.
So I've had cases where dad went to the school to see his kid because mom wouldn't let him see the kid. The One of the school staff members had the resource officer come and stand, basically oversee the dad's interaction with his
Right.
child. Was it right? No. But you're in that situation right then. A lot of times I'm on the phone with them and I'm, calming the situation down, because I have the dad saying, this officer's standing right here. Why should I just calm down, talk to your daughter, talk to your child, just ignore him. He can't stop you from doing it in his presence. Meantime, I've had times when in situations like that, either out in the field or at a school, I call the supervisor. Is it the policy? Is it the policy to stand by and watch my client? There's no court order for it. Can you tell me why? And then talk to the client later on. Yeah, he eventually left. Yeah, let me tell you why he left. Because I called the supervisor and the supervisor told him, you better go find something else to do on campus. So
Right.
that is very big, is your demeanor, your temperament. I had a case where dad had, and then it can have some very sad consequences for not filing. Mom had left the child with dad and the paternal grandmother when the child was 3 weeks old. Dad lived with his mother for all these years, 10 years old. Grandma dies. Mother comes and gets the child. Dad had never filed a case. Didn't know he had to. And that's the other thing, Jamal. A lot of times these dads don't know. Dads don't know that they don't have any rights.
Yeah, I have
That's why they
questions
haven't
for the
filed a
education
case.
part.
But he didn't have an order for visitation. Hey, he think about it. He lives with me. What I need? Why would I need an order for visitation? He lives with me. He's lived with me all his life. But
Jamal, I'm sorry. Did you say you had a question?
Yeah, towards the educational parts,
yes,
a few questions, but a lot of this information is pertinent for what I have to be able to deliver on our Zoom calls with the fathers as well.
yes.
But my only thing as you get going, still, Miss Jackson, in the conversation is once we get to the end of it, just telling us what are some of the things that fathers can do to educate themselves now.
Yes.
Even though I know that this right here is going to be very impactful,
Right.
have this type of information on the website and on the social media platforms. But then when they come into the program, we could be helping them, which we're already doing.
Yes.
Just knowing that I don't know the percentages on how much education each father has, but in our situation with our program, I would say about 75% of fathers, they really don't know what's going on.
I would agree. I have the
same. The other party is ahead of the game.
Yes.
We're moving on what's going on.
But I will tell you this, not really. And I will tell you why. Okay. A lot of moms don't know the law either. They're just saying, we talked about this. I was talking about this the other day. The whole possession is 9/10 of the law. It's not a true legal principle, but it's the truth. It's the truth. And so mom has the child. So it says here entitled to primary care and custody, right? But that doesn't mean mom has the right to dictate to dad, you can't get the birth certificate, you can't get the social security card. But if they're telling them that and dads don't know any different, that's why. There are a lot of moms who have no clue. So Jamal, one of the things is with the time sharing, there are standards in a lot of counties, I won't say most, in Central Florida, and especially the Ninth Circuit, Orange and Osceola, 50-50, it might not be a part of the standard, part of the statute, but you come in and you're going to have to convince them why that other parent shouldn't get 50-50. They start at it. And they've been trying for the last few years to try to get it added to the statute, and they haven't yet. But the reality is that's what you're walking into. That's a very big key. Moms don't realize that. Moms don't realize that if dad's not paying support, he may not be paying support because support has not been established yet. And as part of these cases, support can be established, or you can have a separate Department of Revenue case. But that dad's time sharing with the child, surprise, surprise, is not based on how much money he pays you. And that child support is based on the child support guidelines. So that's very critical. And speaking of that, and I'm going to end in a few minutes here because I see we're going on an hour and a half, and well, no, we didn't start right at 12. I have a few more
after. But really quickly, I wanted to just interject. So Jamal, you were asking what resources, what can the fathers do?
Yeah.
If a child is on the way, I would, as stated before, reach out to an attorney. There are a lot of firms that provide free consultations, or even if they had to pay something, they could still obtain some information, guidance in regards to how to move forward before the child is born.
And let's start there, Vernisha, because that was one of the things I wanted to address. You're right. That's a very good place. Before the child is born, there is a Florida Putative Father Registry. A lot of states have it. What that means is the father goes in and puts his information and says, I had sex with this person, and if there's ever a chance that that child is, because it protects that person for purposes of adoption and gives them the right to be notified for adoption. If a woman puts a child up for adoption, part of that process is to search the Putative Father Registry. So you put it on notice that I may be the father of a child born of this woman, and then you have a right to participate. So that's a very important element that's not used all the time, but that can be very good. And like Vernisha said, it starts beforehand, before the child is even born. Start getting things in place. Another good thing, Vernisha, for fathers, for children before they're born, is helping to pay mom's maternity costs. Childbirth
cash, card, checks, or what?
No cash. Do not do cash unless you standing there and they hit that button that says a tax. Now, Cash App, Zelle, all of those are great. And make sure you put what it's for. I had a case where mom denied that dad had given her anything. Dad had all of his receipts where he went to every doctor's appointment with her, and he paid his half of the copay, right? And some of yet she came in and said he had all of that. So keep your documentation. She also had gotten some of the money had been refunded to her, because you know how a lot of times they run the insurance and then it turns out she didn't have that obligation.
Right.
But because she was a patient and patient accounting, the monies went back to her. He found out accidentally. Something happened. He called to ask something and they said, well, yeah, it was just like those others. You got refunded. He's like, I ain't get refunded anything. So we come into court and she tries to lie about it. And let me tell you, the judge was livid. Wow. The judge was livid when we were able to show, Your Honor, the doctor's office shows, I think we went through the insurance and it showed that it had been refunded to her, and she never gave him his money, his part of the money. So if you can document what expenses you pay, because when it comes time to start child support, that's one of the things that the court can go back to, the childbirth expenses.
So do you recommend in the note section in Cash App and Zelle and everything, what do you recommend that they notate? Like, what should it say?
So for the childbirth expenses, say the mom's name, mom's prenatal appointment, like be specific, mom's prenatal, it's going to have a date on it, right? Or you can say for that doctor's appointment, mom's doctor's appointment on whatever the date, as specific as possible, because what you don't want to happen is for there to be this question, well, what was it for? She could say, no, he gave me money for my tires. I asked him money for the tires, and that's what I needed a new battery.
Right.
It needs to be related to the child. And the
What if
child,
there are receipts for diapers and clothing? How does that affect child support?
you generally do not get credit for that. So before the child is born, you need to be specific about what it is. After the child is born, it is better to, because it's very much up in the air and at the discretion of each judge or hearing officer, whether they give you credit for it. Now, it will show, a lot of times they'll show, listen, he was buying diapers, formula, wipes, that type thing. The best thing to do is give them a sum of money and say child support for and the child's name,
Gotcha.
or the children's names, um, and keep your copy. Even when you're doing, best way is to just create an account, a bank account, and write them a check, because you can get your canceled checks. Because the issue with money orders is, some money order places, you have to pay a fee to get the front and back of it.
Right.
Some of them are free, some of them you can get online. I just had a client recently, before he decided to go ahead and open a bank account. He didn't have a bank account. Um, but what we were going to do is, I told him I would check, because having done this so long, I know that there are some that they will email you the front and back. There's no fee. And then there's others you got to pay $12 for the front and back. And if you have multiple money orders, that can add up.
Right.
That can be quite steep. So again, you're strategizing. And going back to what Vernisha was saying, and what you were asking, Jamal, is some of the things that they can do and the resources. Strategize. Stop, sit down and think about it. Take the emotional side out of it, right? You got to take the emotion, because courts don't rule based on emotions. Courts rule based on evidence. Testimony is evidence, but they like written documentation, written evidence. So, like we said, before the child is born, the putative father registry, um, if you're paying for expenses, for helping with co-pays, insurance, a lot of times they'll have like a fee you have to pay. In this particular case, where dad had all his receipts, there was the deductible. So if you're paying a part of the deductible, and again, as Vernisha said, label it, say what that is. Insurance deductible for child's birth. Say exactly what it is and keep that documentation. Another good point is, you want to scan, if possible, scan and email those receipts, or make a copy of the receipts, because a lot of receipts, good example, some of the things I have fathers do is mail things priority mail, because it has tracking, automatic tracking. And so the post office receipt that has a tracking number on it, it fades. So you go back a couple months later, you may have nothing there.
Right.
And we're going to be in trouble. But if you scan it or make a copy of it, then we'll have it. But you want to do everything you can to document. And then another thing, as far as resources, is online. There's a wealth of information out there. Just go online and search things. Now, we as attorneys don't like clients coming in trying to tell us about what they found on the internet, and
Right.
it's more correct than we are, right? But it can at least get you started and get you to understand. You have pro se parties who, like Vernisha said, some of them can be very savvy, but those are the ones who do their research and take their time. The forms, Florida family law forms, are online, and it is www.flcourts.org. The majority, not every single form, but the majority, but the petition for paternity, the forms to file a paternity case, are on that website, and each form has instructions for that form. What's important about that is, those forms are free. Most of the courthouses have packets that you can go buy, 20, $30, when you can get all those forms online free. And you get that packet and the clerk says, I can't help you fill it out. And it has every form you might need in every family law case. You still got to know which ones. If
Right.
they pay attention to those instructions, the instructions tell them not only how to fill out that particular form and whether it needs to be notarized, some stuff is notarized, some isn't. It will also tell you what are the forms you have to file with it. And there are plenty that you have to file, in order to get that case started. So I
For
would say,
those who don't feel comfortable in completing those documents by themselves, and or they may be financially challenged and not able to afford an attorney, I just want to put the plug in right here that the Virgil Hawkins Fellowship can assist you with navigating this process, filling out these forms, giving you some advice. And if you qualify financially, the services will be provided for free. That's right,
yes.
for free.
And go ahead, Jamal.
Duly noted, huge key.
Yes.
But I did have another point on top of that great point from the Virgil Hawkins Fellowship with Venetia. When you talked about the bank account with the children, because what we're seeing inside of our program is that I'd say about 30% of our fathers, there's not good communication. 30 to 50%. There's not good communication between the other guardian.
Right.
So when it comes to the payout situation, when you're paying your child support, I know that you pay through the court, Orange County clerk, correct?
Yes. Well, no, not in Orange County. They only accept lump sum. It varies based on your county. That's another thing, varies based on your county. Majority, if there is a court order for child support, it is through the state disbursement unit in Tallahassee.
Yes, ma'am.
But only if you have to have a case already established. So what we were talking about, Vernicia and I were talking about, if they're just giving it to the other parent, that's when I recommend mailing it by priority mail.
So therefore, if you don't have established paternity, you can do the bank account and it can be accounted for when you go to the court.
Right.
Comes up.
In preparation for.
Yes.
Correct. So if you are inside of the court system, then you have to go through Florida State Disbursement Unit.
Yes. And then a record of that is kind of confusing. The record of it is kept at the clerk of courts. That's where you go get your printout. There used to be both. There used to be one out of Tallahassee and one in the local courts. Now the clerk of courts is the official record keeper. So even though your payments are going to Tallahassee, Tallahassee is recording it in the state clerk's website. And so you go to your local clerk of courts. That's where you get the record of your payments. Okay. And so two different things. When there is a court-ordered child support, it has been established through the courts. You do the state disbursement unit. A lot of times those orders will say you make direct payments until it goes through the state disbursement unit or it starts coming out of your check, right? In those instances, when you're paying direct, you don't send it through the kids. You don't put it in the diaper bag. You don't go put it in her mailbox yourself. You mail it. Priority mail. Priority mail, there's tracking. Yeah, $6 or $7, but trust me, it'll be worth it because for child support, they can go back 24 months prior to the date that they file the case that the parties didn't live together. And that's the other thing. If you live with someone, we have that now with the Virgil Hawkins program, a case where the parties live together. But mom says she's going to get some child support, so I've had to file a motion to dismiss and say, they live together. Right. She waived arrears. Arrears is that portion before you live together. I'm sorry, before the case was filed, the 24 months. So when child support is set, they're going to set the arrears and the ongoing. And that arrears can go back 24 months. So it's important that's why it's important for them to document, because even if they don't have a legal obligation yet and they're paying support, because they can be voluntarily paying support. And I actually encourage that as well. Even if they haven't taken you to court, you go through and you pay, $100 a week or whatever it is you can afford, document it, that is, child support, and then you will get credit for it. That's when you'll get credit, when it's documented that you've paid it. All these buying diapers, formula, that type thing, that's when, you know, it can be difficult to do it. But like I said, Cash App, Zelle, those types of things, text messages. I had a situation where I told the dad, and don't let them rush you. Well, you know what? It takes too long to go through Tallahassee. I don't care. You're going to have to wait on that. You're going to need to wait on that, because I told my client, do not send any direct cash payments, no matter what they say. Don't you know, got time to child support, and say, I think it was 3 direct payments. Wasn't a lot, but it was 3 direct payments. And mom was saying, yeah, I got 1. I don't know what he's talking about the other 2. But what he had her do was acknowledge through email that she received it. So we had the email where she said, yes, I received it. Thanks so much. So we went through this whole thing. The hearing officer did not appreciate it, because she made me go through this whole thing. She went through this whole looking back in her account records. You know how you can pull it up on your phone. Nope, don't see it. Nope, I'm all the way back. You know, I'm 2 years back. I don't know what he's talking about. That's what he had done. He had deposited into her account. So he had his receipt. He didn't have his receipt. At the time he had it and said, please acknowledge. So he required her to acknowledge. We went back. I said, Your Honor, can we have a recess? She didn't think he had it. Can we have a recess? You know, my client has it, is, you know, out in the hall. Came back and she's like, oh, those 2 payments? Yeah, I got those. Is that email from, you know, and the hearing officer, because they look at your credibility too. That's the other reason when I was telling you that these fathers, when they're in court or anytime they're dealing in these situations, you know, keep note that the court is looking at your demeanor and they're determining whether you're credible or not, you know. And with the time sharing and what the courts will determine, yeah, if you're in there looking like a hothead and you're gonna fly off the handle, and that's what mom is saying. I had a client who unfortunately almost turned over the table in mediation, jumped up, banged the table, gave this long speech about something about the African Sahara. It was something. I knew he had planned it. And look over, and wife is over in a corner cowering. She should have gotten an Academy Award, but he walked right into it. She's saying you're violent, you know, and you're in mediation, losing your cool, banging on the table.
You sound true. Right.
So you just have to, and a lot of times the other person, keep in mind, they're going to try and trigger you. You know, and so I don't buy into that whole thing. And I tell both parents that, well, they know how to push my buttons. As I told the client, you don't have any damn buttons. Listen,
ain't no buttons over.
No buttons.
Right.
Push a button. But you know, really, you can't fall into it. It's a strategy. You know what the other, and a lot of times I've used it to my advantage when you have a hothead other client and you know that they're going to be in there, and you know, one of those Matlock moments when they tell them, you know, no, Your Honor, you're in contempt. You'll be surprised at what some people tell judges.
Yeah.
And when they're on the other side, I tell my clients, is there going to be one jackrabbit in the courtroom? It's not going to be my client.
Right.
I hear that.
Really quickly, I just want to make sure that we make a note that oftentimes fathers overlook documentation that is important, that has deadlines. So if you receive anything talking about child support from an administrative agency, Department of Revenue, or if you're served with it, make sure that you respond, because responding.
Make sure that your family members tell you, because they can serve, and that's for any court process, they can serve anyone in the household over 15 years of age, 15 or older.
Just drop it off.
So if somebody else gets it, signs for it, and says, yes, that person lives here, you are deemed to have been served. And like Vernicia was saying, there's deadlines. At the beginning of the process, you only have 20 days. And Department of Revenue, I think some of their stuff in it 10 days. There's some stuff that is 10 days. You know, so it's very important. It might be buried in there. So yeah, and we're gonna have to do another one of these because I didn't get on the child support part, Jamile.
Yeah.
There's a lot. I want to do one just on child support because there are a lot of nuances with that as well. I'll just touch bases real quick. There are multiple ways to establish child support. It can be established through these paternity cases, right? That's a circuit court case. Department of Revenue can establish it through the circuit court as well, but they also can establish it through an administrative support case, also known as the devil, Satan's spawn. It is an abbreviated process that you don't even get a hearing. As part of that process, you don't get a hearing unless you request it. And it's kind of buried in there if they don't know what to look for. And when you were saying resources and what these fathers should do, read it. Don't ignore it. Act on it. Be proactive because it can have some very serious consequences. For instance, arrears. Once arrears are established, they are vested. They cannot be removed. They cannot, absent some very, it has to be some serious consequences and some legal maneuvering to get it undone. And you're talking thousands and thousands of dollars. And when Department of Revenue is involved, that lump sum amount of arrears goes on your credit. And it does not come off your credit until it's paid in full. Even if you're paying monthly towards it, until that entire balance is gone. And sometimes you could be talking $30,000, depending on how much your monthly child support is. In that 24 months, it can be a substantial amount of money. But even if it's a few $1,000s, that's on your credit.
Right. I have a situation, Ms. Vermata, before we get off, with one of the fathers. So say the parents are actually coming to agreement after being through this whole, situation of being back and forth through the courtroom and having hearings and whatnot. Now they're coming to agreement. Is there a way to remove the court system out of their usage where the court system doesn't have any jurisdiction over the child now? Are they able to remove that or disestablish child support?
No. Yes and no. Yes and no. It's on a case-by-case basis. What can be done, I think that was Venetia, I was just telling you the other day that I saw some case law when I was doing some research. I got to make sure I find it. That talks about the fact that agreements can be reached. Oh, I think that was on the bench bar conference, Venetia. Agreements about child support can be reached. So the court can do it, but you can't, what the law does say is you can't waive child support. A parent can't waive the child support because the child support is owed to the child, not to the parent, right? But that again is a situation where you really got to know what you're doing. Because that's one of the, you probably hear a lot, well, the mom says she'll take me off child support. That'll be a no. You submit something to the court that says, nope, he doesn't have to pay child support, it's getting rejected. But you can reach an agreement on it. For instance, dad might not pay child support because he's agreed to pay all of the extracurriculars or if there's travel. So it's offsetting something. So there are agreements that can be reached about child support, but they have to, conform with the law too. So you have to be careful about what it is you're asking the court to do. The court won't necessarily come out of it because it's still a court case, right? But what they can do is adopt the agreement of the parties, and it has to be reasonable. If child support, because there's a method to deviate as part of the process. You can deviate from the child support guidelines amount. So you can ask the court to deviate, but it has to be reasonable, and you have to have a valid basis for it. If you just say, I want to deviate, the child support guidelines say $750 and I agreed to take $2, that would be a no. It has to have something to offset it. Dad is taking on some other expense of the child. Dad lives, out of state. And so he's having to pay for his travel, which is one of the things that you can get credit for, travel expenses, that type thing. Jamile, another thing that I want you to have fathers to familiarize themselves when I say go online. look at the Florida statutes, read them and see what they say. Chapter 61 governs, is like the Bible for family law. It deals with paternity, it deals with dissolution of marriage, it deals with child support. All of those are under that. And then what is it? Chapter 740 to 700s. There's some more that talks about domestic relations, and that deals more so with unmarried fathers. That's where that section comes in about natural guardians and that type thing. Chapters 741 to 753 is called domestic relations. And so there's, you know, different things in there, 741, 742, 744. So they need to familiarize themselves and be familiar with it. Chapter 61 outlines the public policy of the state of Florida. And that public policy, which changed a few years ago, well, not a few years ago, it has changed for a while now, says that there's no presumption in favor of either parent. That, you know, basically you're on the even keel when you go in there. That's why the 50-50 is so prevalent, is that you can go in saying we're coming in here on equal footing. I'm looking for it to see what the language says, and I use this in my pleadings a lot because sometimes you have to remind the courts as well.
And Ramada and Jamal, I'm gonna have to step out or step off because I have a meeting at 2.
Okay, yeah, I'm gonna read this and then we can be done.
Okay.
It says, it is a public policy of this state that each minor child has frequent and continuing contact with both parents after the parents separate or the marriage of the parties is dissolved, and to encourage parents to share the rights and responsibilities and joys of child rearing. There is no presumption for or against the father or mother of the child, or for or against any specific time sharing schedule when creating or modifying the parenting plan of the child. That's huge. So it's in the statute. You know, they need to read it, familiarize themselves with it, and then govern themselves accordingly.
Yeah, I'm going to
And
do
they
this.
can't come to us.
That's right. They can come to us for help.
Any questions, we're coming this way anyway.
Yes.
We've established that part for sure.
Yes.
I appreciate your time. I think we should do it again. I would like to come with, I had a few questions, but you honestly ran through most of what we need. And maybe the next time we speak, I can come with some specifics that I'm seeing.
Okay.
And able to get it answered directly for what some of the fathers are going through. And that'll help you out if we start bringing cases that way. You'll be able to already be familiar with their case.
That'll work.
So, Vernisha, I appreciate you. Thank you so much for making the time. Ms. Ramada, I appreciate you as well. Thank you all. I'm really excited about the partnership with Virgil Hawkins Foundation. And if you all get the time, follow our Instagram. It's at WeFam_org.
Okay.
And also our website is www.wefam.org. But we're already partners, and we're happy to be able to start bringing fathers and bringing men into your organization to help them find some success and be able to encourage those healthy relationships with their kids and family and communities as well.
All right. Thank you so much, guys. You have a nice afternoon.
Yes.
Bye-bye.
Bye-bye.